Welcome back. This content is for educational purposes only and does not constitute legal or medical advice. If you have filed a complaint in the courthouse and it was challenged, please don't walk away and don't give up. Today, I want to show you how I used the Illinois Civil Rules of Procedure to draft my second amended complaint to withstand a motion to dismiss. Welcome to the first episode of Sovereign Science and Law. Before this was Hamza's Advocacy, I changed things up. I want this platform to go much further than I originally intended. I want to actually help people. I have stuck it out for 10 months in court, and I didn't actually think I was going to go that far, so I just made these videos so I can go back and watch my videos, learn anything from myself, hear myself speak. But this has actually turned out to be something much greater than I anticipated. So I'm back today, 2 months later after making my 13th video, and I'm here to show you my second amended complaint. Not this hearing I just had March 17th. The hearing prior, I was given a speech by the judge. He explained to me that this is a fact pleading state. He asked me if I read the Illinois Civil Rules of Procedure. I told him I did, and I have, but did I understand them? I thought I did, but I didn't. One particular rule I want to talk about today in this video is, it's Rule 15 actually. And so, let me pull this up. So Rule 15 is about the amended complaint, okay? That's basically what Rule 15 is. But the exact code of it is, sorry about that, it is 735 ILCS 52616 amendments, okay? So this one is, to simplify this, amendments before trial. So you have one free shot to amend within 21 days of serving it, or 21 days after responsive pleading, like a motion to dismiss. And so that's what I had, a motion to dismiss again. And I actually survived that motion to dismiss. It's like the judge is allowing me, he keeps on indirectly telling me what I need to do. And so I go back and do it, and I come back and he's got something else for me to do. And he doesn't completely grant the motion to dismiss. He gives me time to go ahead and re-amend things. And that's what I did this time. I re-amended this. And so since I am on my second amendment, since I'm on my second amendment, I believe I can go back again, because that's what they plan on doing. I found out at March 17th. I found out that the defendant's gonna, because we went in for another hearing. It was just a status hearing, and I found out the defendant's gonna go ahead and file the motion to dismiss, which is fine. They can go ahead and allow me to amend it again, which may possibly happen. But here's my second amended complaint. It's completely different. I even put the little parentheses down the middle. Okay? And then one thing I realized is that because it's fact pleading state, is that I need to organize it differently based on the Illinois Rules of Civil Procedure. This is a juice. My apple, celery, parsley, cilantro, lemons, cucumbers, ginger juice. It's really good, actually. It may sound odd, and it's even better when I put cayenne in it. But anyways, regarding the fact pleading state of Illinois, I have to, instead of, see, my prior complaint that I read to everybody, I compiled the paragraphs, and each complaint within the article that I drafted, all the paragraphs were crammed into. I was pleading facts, but I was also stating that my opinion, putting a lot of emotion into it, and it wasn't what the court needed, nor did it follow the rules of civil procedure. So I had to break everything down section by section. So I have a complaint here. Let's say the jurisdiction and venue. This court has jurisdiction over this matter pursuant to the Illinois Constitution, Article 6, Section 9, as this case involves claims arising under Illinois statutory and common law. So I broke that down in 6, 7, 8, 9, and so on, 10. And so I had to break down each paragraph into its own number, to its own sentence. And I know that we typically think of a paragraph, it's like a paragraph is 3 sentences or more. It's not that way in court when you're drafting a court document. It's fascinating. So I learned a lot from the Civil Rules of Procedure. I studied it for 30 days. I read it over and over again to understand it. And so basically I come back, I redrafted this, I go to court, and what had happened was it was a status hearing, so we were still trying to get the individual. One party has not been summoned or served yet in this case. And this individual, I don't know what the issue is, but I found this individual, and because I found this individual, I'm going to go ahead and I'm going to use ABC Legal. ABC Legal is somebody it's somebody outside the Sheriff's Department who serves individuals, and they're federally recognized. So it's a really good company to have summons and serve these individuals. Well, what I really want to do here is I want to go back over this and read this. I have a lot to read here, so I might not read it all. So it starts with the parties. Filed in the courthouse of Vermilion County. Jurisdiction and venue. This allows the court to be granted a jurisdiction over you. Having the parties being served gives the court jurisdiction over them. So then we have general allegations. On or before August 28, 2024, plaintiff entered into a residential lease agreement with defendant Mercy Housing, which was subsequently renewed via a tenant income certification effective February 1st, 2026 for the premises located in Danville, Illinois. Relevant portions of said lease are attached hereto as Exhibit A. So that would be paragraph 10. And then it goes on to paragraph 11. The subject property is a residential complex specifically designated for United States veterans and is operated in coordination with the Veteran Administration, VA, and the Department of Housing and Urban Development, HUD. Prior to June 5th, 2025, plaintiff maintained a clean tenancy record with the documented lease violations or disciplinary notices. On June 5th, 2025, plaintiff met with defendant Melissa Taylor to discuss matters regarding a vehicle on the property. During this meeting, plaintiff peacefully asserted his lawful rights and expressed concerns regarding the management's handling of vehicle policies. I talked about this earlier before in my other videos. You can go back through, as you should. Go back through and watch the videos. It might not be that great. This may not be that great, but it will give you information to be able to write your own complaint. I'm going to help you. If you just follow along, you can even reach out to me, and we can figure this out together. So paragraph 15 on June 6, 2025, less than 24 hours after the meeting described in paragraph 13, defendant Taylor and LaBounty issued a written lease violation notice to plaintiff. A true and correct copy of said notice is attached hereto as Exhibit B. So basically, paragraph 16 says on June 6, 2025, I got the notice that said I harassed, bullied, and threatened them at the office. I didn't do all that. And this just goes through everything, all the procedures I took. I talked to the assistant property manager. And then I talked to the property manager, then the assistant property manager, and then I talked to, well, by then I told them, I said, hey, listen, I sent them a notice of intent to sue. I'm intending to sue you, to bring a judge in the middle of us to find a middle ground if we can't figure this out. And so that's what happened. I am here now. And so I'm going to skip all this story because I go over the story and I'll make this very long. But count 1, First Amendment retaliation. This is against all defendants. So paragraph 24. Plaintiff incorporates by reference the allegation contained in paragraph 1 through 23 as though fully set forth herein. Paragraph 25. Plaintiff's peaceful assertion of his lawful rights regarding his vehicle and housing conditions on June 5th, 2025 constitutes protected speech under the First Amendment to the United States Constitution. Defendants Taylor and LaBounty issuance of a false lease violation on June 6, 2025 constitutes an adverse action that would deter a person of ordinary firmness from continuing to engage in protected speech. Paragraph 27. There is a causal connection between plaintiff's protected speech and adverse action as evidenced by the less than 24-hour time frame between the protected activity and the issuance of the violation notice. 28. Defendant acted under color of law because Mercy Housing is a government-funded entity performing a public function of veteran housing in coordination with the VA and HUD. Now, this one is a touchy subject here because I don't know how this is going to work out in court. Claiming that they're acting under the color of law usually does not work for a private entity, only government officials. But they are tied into government officials, so I'm pushing for it. The bullying, harassment, and threats allegations were a pretext used by defendants to punish plaintiff for his speech and to silence his future advocacy for his rights. 30. As a direct and proximate result of this retaliation, plaintiff has suffered a chilling of his First Amendment rights, reputational harm within his residential community, and severe mental and emotional distress. Now, make sure you all are very clear about that. Be very clear about what this has done to you. I mean, when I say severe mental and emotional distress, I've been dealing with this for 10 months while taking care of my 7-month, 8-month-old son now, while going to school, while working, and so forth. All of this could have just been easily wrapped up and dealt with if they would have just originally removed the lease violation from my tenant record. If they would not have falsely accused me of threats and harassment and violence. Okay? I did no such things. Whatever. Anyways, going forward, it doesn't matter what I say I did. It matters what the court finds valid and invalid in the near future when we take this matter to trial or however it stands. Anyways, count 2, violation of the Illinois Landlord Retaliation Act. This is against defendants Mercy Housing Incorporated. Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 30 as though fully set forth herein. At all times relevant, plaintiff was a tenant and defendant Mercy Housing was a landlord as defined by 765 ILCS 721-5. Again, on June 5, 2025, plaintiff exercised a right or remedy provided by law by peacefully complaining to management regarding vehicle policies and asserting his rights under the lease. So this goes back down the timeline. Skip to paragraph 36. Pursuant to 765 ILCS 721-15, because the adverse action occurred within the year of plaintiff's exercise of his rights, there is a rebutable presumption that the defendant acted in retaliation. So that just sums up the fact that, yeah, this is retaliation under Illinois law, Illinois statute. And then let's go ahead and move on to account 3, defamation per se. So against all defendants. And I put that in parentheses because I want to know what count is being directed at who, or which count is being directed at who. It's very important to make things as easy as possible for the judge. If you make things easy as possible for the judge, calm, patient, respectful, you show emotional intelligence, I think things will go the way they have for me. I'm a pro se litigant. I'm not an attorney. I'm not a lawyer. I have not entered in law school yet. I'm still studying for my LSAT. I just know my rights. And I came in and I showed perseverance. I faced my humilities, even though there was times where I was wrong and I wanted to give up and walk away. I said, you know what, I'm just going to continue. That's what I did with this second amended complaint. I wanted to give up. I was humiliated. I was just like, I don't think that there's any validity here. And then I continued to read the Illinois Rules of Civil Procedure, and I said, there is validity here. There is. And I have to do what I believe in, and that is holding these corporations accountable for violating people's rights, for infringing upon people's rights. I'm not a veteran. My fiance is a veteran. So, even so, it's not only her that they are, her rights they are infringing on. It's other veterans that live here and other veterans who have left here because of their actions. So somebody has to stand up to these people, and I just like, you know what? I'm going to keep going until the judge tells me enough is enough. And the judge has not done so yet. The judge has allowed me, time after time, told me, without directly telling me, because they cannot, in court, they cannot tell you the law. They cannot, they're not there to give you legal advice. They cannot give you legal advice. Legally, they cannot give you legal advice. You are expected to be a competent individual and to figure things out on your own if you want things to happen, if you want things to move. And that's what I've done, and that's why I showed the judge I'm willing to do. Because of that, I have been granted opportunity after opportunity, and because of that, I have surpassed what most pro se litigants would actually fail on. And that, I mean, most pro se litigants would fail within 3 months. But I decided not to give up. And I'm going to go until I get my 50,000 plus. I guarantee that. And this isn't just about money. This is about creating policy. Policy for which individuals or persons, such as corporations, where they cannot infringe upon people's rights. No matter what the law, what their bylaws are, they cannot infringe on people's rights. So yeah, defamation, you understand defamation. Plaintiff, 41. On June 6, 2025, defendant Taylor and LeBounty authored a written lease violation notice stating that the plaintiff had engaged in threats, harassment, and bullying. 42, these statements were false, blah, blah, blah. 43, defendants published these false statements by entering into the plaintiff's permanent tenant file. 44, defendants acted with malice, or at least reckless disregard for the truth because they issued the notice less than 24 hours after plaintiff asserted his legal rights, using the false accusations as a tool for retaliation. See, how many people actually get lease violations from their landlords and they just take them as they are? Enough is enough. Got to do something about this. Got to stand up and hold these people, these persons, as they're you got to hold them accountable. The statements in 45, the statements constitute defamation per se because they impeach plaintiff's reputation for honesty, integrity, and peaceful law-abiding conduct and suggest a propensity for criminal-like behavior, threats. As a direct result of this publication, plaintiff has suffered presumed damages to his reputation, as well as actual emotional distress, humiliation, and fear of future housing denials based on the falsified record. Then I go on to my prayer for relief. Wherefore, plaintiff TDL respectfully requests that this honorable court enters judgment in his favor and against defendant Mercy Housing. See, my name before was Tony David Leonard, but I have legally changed my name to your host, Leonidas Hamza. Okay. Anyways, we go on to declaratory and injunctive relief. A declaration that the June 6, 2025 lease be removed. Issued violation of First Amendment. Yeah, factually false. We wanted to say it's factually false. 2, a permanent injunction ordering defendants to physically and electronically remove and expunge June 6 lease from their internal database. 3, an order prohibiting defendants from taking any further retaliatory actions against plaintiff during for the duration of his tenancy. So then we move on to monetary damages, compensatory damages for emotional distress, humiliation, and reputational harm, and an amount to be proven at trial. 2, statutory damages pursuant to 765 ILCS 721-25. Specifically, an award of twice the actual damages or 2 months' rent, whichever is greater. Okay? Punitive damages against defendants in an amount sufficient to punish their willful and malice conduct and to deter such conduct in the future. Total monetary damages in the amount of $50,000 plus cost of suit and any other relief this court deems just and proper. And then I enter in a demand for jury trial. So, enter in a demand for jury trial, verification by certification under penalties as provided by law pursuant to Section 1-109 of the Code of Civil Procedure. The undersigned certifies that the statements set forth in that instrument are true and correct, except as to matters therein stated to be on information and belief, and as to such matters, the undersigned certifies, as aforesaid, that he verily believes the same to be true. Respectfully submitted. And then, so, what we sign, your name, -S Leonidas Hamza. And it says, Leonidas Hamza, plaintiff pro se, formerly known as TDL, Tony David Leonard. I don't like saying the name, but whatever. It was my name. And then I went on to, I created this nice little map. Has all my exhibits A to D. And then I created a cover sheet. I did not put, if I put all the lease portions in there, the lease itself was like 99 pages. So I did relevant portions of residential lease agreement. If this is a tenant issue, you go through. That's a cover. I'm going to stop it right there because there's a lot in here, and it is what it is. But like I said, if you are doing this against the landlord, read your lease. Know your lease in and out. I've read mine. There you'll find some silly things. You'll find some really interesting things. And you'll find things that just, actually, always sign your lease without prejudice and without recourse. If I'm not mistaken, without prejudice is UCC 1-308. I know that one more than I know any of them, because when you sign without prejudice, you're telling them like, hey, I reserve my rights. I know my rights. I reserve my rights. No matter what I sign in here, I reserve my rights. So if you try to hold me accountable for anything that I feel like is infringing upon my rights, as a United States citizen, well, I'm going to take your ass to court. And in court, I'm trying to find where I signed without prejudice. Oh, but yeah, I'm going to take you to court. I'm going to let the judge know that, hey, I signed without prejudice. And see that? Without prejudice. Leo Nizhamza. Okay? You sign in such a way, reserve your rights, then you put on one hell of a fight. And your fight is not the way that you fight on the streets. Your fight is with your mouth, and it is with your mind. It is with your heart. Patience. Be patient. Be wise. Don't act like a fool. Don't be emotionally unintelligent. Lead by example. Be a leader and create other leaders. As I said, this has been a 10-month journey. I've documented every step. So going forward, I took the 13 videos and I put them into its own playlist called the Pro Se Litigation Blueprint. I will most likely go ahead and create a new playlist for this video and the videos going forward, because this is a new platform, essentially. This is sovereign science and law. So always remember, our story is not over. And that's my punchline. Thank you for sticking around, and I hope this helped you out. If you need anything, reach out to me. My email is lhsofficeone1@gmail.com. If you need anything, reach out to me. Let's talk about it. Other than that, peace out.